The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Here.
Green. Young. Here. Arbit.
Yep.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller. Bazat.
Here.
Harris.
Here.
Begol.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the October 24th meeting. Without objection, the minutes are adopted. My standard announcement, if you would like to speak during today's hearing, please make sure to turn in one of the white cards. And we will now hear testimony on House Bill 5075. Here to testify is Representative Bazat. Go ahead and get started whenever you're ready.
Thank you, Madam Chair. Committee members, good morning. Thank you for taking up House Bill 5075. This originated from a detective from Farmington Hills, Nate Jordan. He called me at the beginning of the year and said that on the Nassar case, MSU case, we had over 100 victims, and he was charged for each victim. But on second, third, and four, it's only one charge. You can have 10 victims but only one charge. So what this bill does, it deals with issues specifically for second degree to fourth degree. Currently under Michigan law, these lesser offenses can only be served concurrently, meaning no matter how many offenses you are convicted of, your length of jail time is only equal to the most severe offense. This hinders the ability of the justice system to properly sentence for proven sexual predators in multiple offenses. House Bill 5075 would rectify this by allowing a judge the discretion to issue consecutive or concurrent sentences based on the facts and the severity of the case. And this is a pro-victim bill, and it proposes, like I said, if you have 10, 20 victims, each victim is traumatized. It's a horrendous crime, and based on the facts of the case, the judge can decide if they want to run it concurrent or consecutive. So that's what this bill basically does, Madam Chair.
Thank you. Questions for Representative Bazat? Representative Filler.
The judge doesn't have to go concurrent. The judge has a choice one way or the other, right?
That's correct. That's what this bill gives us the
Not
option.
mandatory.
No, just based on the case facts.
Thank you, Rep.
Anybody else? You must have done a good job. Thank you.
Thank you, Madam Chair.
We do have a card here from Matt Saxton from the Michigan Sheriff's Association, who supports the bill. Does not wish to speak. Okay. And Cheryl Collins supports this bill, does not wish to, well, she does wish to speak, but on the other bills. I don't care. Okay, thank you. We'll now turn to the Justice for Survivors package. We took testimony on these bills, seems like a lifetime ago, on June 6th. We'll have some brief testimony from Rep. Brixey. You may come up with your witness there. Wherever you're comfortable is fine with me.
Thank you, Madam. Thank you, Madam Chair. I'm Julie Brixey. I'm a state representative from Meridian Township. Last June, good morning, committee members. Last June, you heard testimony from me, from survivors of sex abuse, and from national experts who discussed our state's narrow statute of limitations for criminal sexual conduct and how our own laws here in Michigan harbor sexual predators and silence their victims. I've been working on this package the entire time I've served here in the legislature, and I'm so grateful to have it on the agenda today. Representative Filler? Representative Filler?
Representative.
Can I have your attention, please? for this
Representative,
brief moment of testimony?
these members are on the committee. I'm talking to them during the committee, and I will continue to do so. We're listening to your testimony also.
I've spent countless hours working with stakeholders to improve the legislation since you last heard testimony. And I wanted to take a moment to offer the substitutes and run through the changes. We provided H1 subs for HB 44, 84, and 87 that strike repetitive language while clarifying that the package is only subject to the 2-year revival window of HB 44, 82 and does not open a permanent revival window. The H3 sub for 4486, the bill that removes governmental immunity, makes that change as well and limits public entities that can be held liable for CSC to educational institutions including K through 12, public academies, and higher educational institutions. Children spend the bulk of their lives outside their homes and school, and we have a duty to protect them when they're in the care of these public governmental institutions. People or organizations that enable and harbor serial pedophiles and serial predators should be held accountable and should not be allowed to be shielded through a cloak of immunity. Thank you for your attention. I'd like to introduce Greg Gugamus to offer testimony.
Good morning. It's a pleasure to appear before this committee. My name is Greg Gugamus. I am 74 years old. I've been married to my wife, Mary, for 53 years, and we have 2 sons, Matthew and Jeremy. I'm a lawyer licensed to practice law in Michigan since 1975, and except for 2 years when I taught at Vermont Law School, I've practiced law in the greater Lansing area until the summer of 2009. It is an honor and privilege to appear before this committee and share the facts about my journey, which started when I was 5 years old and was successfully resolved when I was 61 years old. In addition, I feel it is my duty to support the legislation proposed by Representative Brixey in order to provide other victims of sexual abuse, regardless of the age at which it occurred, the opportunity to have their voices heard, hold their abusers and enablers accountable, and for justice to be done. My journey started in 1954, when I was 5 years old and at the St. Vincent Orphanage in Lansing. I was there for about 9 months. As I grew older, I noticed that I had absolutely no memory of what occurred while I was at the orphanage. It was like I was never there. In my late teens, I started experiencing repeated bouts of depression. I had no idea what was causing them. Back in the 1960s, the opportunities to obtain mental and emotional medical care were limited. In addition, as a male, at that time, in the 1960s, admitted having mental and emotional problems was simply not cool. My periods of depression continued after I became a lawyer, and when I was 40, I decided to start seeing a psychologist to help me cope with my depression. Until I was 50 years old, I never discussed with her that I had no memory of being at the orphanage. When we started addressing the absence of my memory of things that occurred at the orphanage, I decided it was time for me to visit the orphanage, walk around the building to see if it would jog my memory about being there. I arranged a meeting in the December of 1999, 45 years after I was there. I took a tour of the building. As I walked around, I started remembering things, and in my mind's eye, I recalled them and viewed them as if I was 5 years old. I remembered the linoleum on the floor, one square with a white background with green streaks, and another square with a green background and white streaks. I also remembered that the walls had ceramic tile on them, and the tile went up about 4 feet from the floor. I then went to see the room where I lived. It was on the south side of the building. When I walked into the room, I remembered the windows on the south wall. I then walked down a hallway, and where it ended, I looked to my left, and I saw a door that led to the outside of the building. When I saw the door, I had an immediate knot in my stomach. My heart rate increased rapidly, and I had trouble breathing. These symptoms lasted for about 30 seconds. After I regained my composure, I finished walking around and continued to remember other parts of the building. After I finished the tour, I spoke with my psychologist, and after a few sessions, I remembered one event when I was sexually abused. I was in the basement of the rectory, standing at a table, and I wasn't wearing any clothes. At that time, I decided I would not pursue any case against the Lansing Diocese for the pain and suffering I experienced as a result of being sexually abused. I was a very prominent lawyer in Lansing with a very solid practice. I was concerned that if I pursued such a case, that it would hurt my practice. I also felt that such a disclosure would be embarrassing to me and my family. In 2009, I decided to leave private practice and become general counsel for the Chrisman Company, major general contractor. My last project before I left private practice was the Accident Fund building. Fascinating project. Chrisman's offices are located just to the north of this building. And Chrisman bought what was the old Michigan Millers Insurance Company's office building and renovated it as a historic structure. Even though renovated, every effort was made to preserve the unique and historical parts of the building. When I started working there, I walked up and down the steps to my office, as opposed to taking the elevator. At 60 years old, I wanted to get in as many steps each day as possible. After 2 or 3 weeks after I started working at Chrisman, my depression started again, and I experienced a tremendous sense of fear. My condition deteriorated rapidly. Things got so out of control that my wife took me to the emergency room at Ingham Medical. I was there for about 8 hours. The psychiatrist who treated me told me I went through a repressed memory episode which caused me to remember that I was sexually abused while at the orphanage. And upon remembering the events, I experienced post-traumatic stress disorder. I was prescribed various medication to help stabilize me. When I returned to work and was walking up the stairway to my office, I noticed for the first time that the linoleum on the steps had the same type of linoleum that was on the floor at the orphanage. Green background with white streaks, a white background with green streaks. I also noticed that the stairway had ceramic tiles on the walls, which went up about 4 feet from the floor. The linoleum and tiles in the stairway were identical to that which was at the orphanage. I discussed this with my psychiatrist, and he believed that seeing the linoleum and ceramic tiles in the stairway were the triggering events for my memories of being sexually abused to no longer be suppressed. While I was on medication, it was not stabilizing me, and as a result, I had to resign as general counsel for Chrisman in July of 2009. My condition was so bad I did not think I could properly discharge my duties as a lawyer. After I left Chrisman, I decided to pursue a case against the Lansing Diocese as a result of my being sexually abused. In the fall of 2009, I met with my good friend Dave Middleman. He is a lawyer, and asked him if he would represent me so I could pursue my case. David agreed to represent me, even though 3 other lawyers told me that my case was barred by the statute of limitations. Under Michigan law, experiencing repressed memory did not toll the statute of limitations. Dave and I met with 2 priests of the diocese and then a lay committee consisting of between 10 and 12 individuals. The priests and the committee found my story to be credible. In 2010, negotiations started with the diocese, and I settled my case in July of 2010. After I settled with the diocese, I decided I would go public about my story and the settlement. I wanted to share both of these things in hope that other victims of sexual abuse would come forward and seek the necessary recourse against their abusers and enablers. A press conference was held in Dave's office, and I told the members of the media my story about being sexually abused while I was at the orphanage. This occurred in August of 2010. Once I went public, my mental and emotional status improved dramatically. I no longer felt embarrassed or shame about what I went through. Disclosure was therapeutic. I felt empowered. The settlement provided accountability for my abusers and the enablers, and gave me a sense of justice, that justice had been served. I did nothing wrong. I was a victim, and most importantly, a survivor. Since I no longer felt shame and embarrassment, I then became an advocate to help other victims of sexual abuse. I spoke with numerous victims and provided them with support and guidance to assist them. I also wrote numerous letters to the editors regarding the pain and suffering experienced by myself and other victims of sexual abuse. I currently live about 20 miles north of Traverse City, and with the exception of one letter to the editor, they were all published in the Traverse City Record Eagle. State Journal found out about one letter, called me, and said, would you be willing to write an article about sexual abuse as a guest writer for the Sunday editorial page? How could I say no? My article appeared in the Journal in January of 2016. I no longer experience fear, embarrassment, or depression. I do continue to take medication to help with the after effects of having gone through post-traumatic stress disorder. I urge this committee to refer the bill to the House of Representatives. At least 25 other states have passed legislation similar to this. A recent poll disclosed that over 70% of the people polled in Michigan support this proposed legislation. This legislation is necessary in order for Michigan law to provide the mechanism to hold abusers and enablers accountable, provide compensation for the countless number of victims who have been sexually abused, and most importantly, to protect the vulnerable going forward. The Michigan State University Nassar sexual abuse scandal is an example of accountability and justice that required legislative action and lobbying to achieve. These reforms were woefully inadequate, as the survivors of the University of Michigan's football sex scandal did not have such a pathway to justice in our legal systems. These bills before this committee would have allowed victims of both tragedies a pathway to justice with the help of the intervention from the Michigan legislature. Victims of sexual abuse shouldn't have to hire a lobbyist to get laws changed to hold serial pedophiles or their enablers accountable. Before making my final comments, I'd like to publicly thank people that assisted me and supported me as I went through my personal hell during 2009 and 2010. First and foremost are my family members, my wife of 53 years and my sons. Provided me with love and support during my darkest hours and continued to do so. I also publicly want to thank Phil and Sylvia Fredrickson, longtime friends of Mary and me. Both of them stood steadfastly by us during our journey. As an aside and a little bit of irony, Phil is the former president of the Chrisman Company, and he hired me to be Chrisman's lawyer back in 1985. I'd like to thank all the members of this committee for giving me the opportunity to present my story and my journey. I implore each of you to vote to reform Michigan's archaic, arbitrary, and predator-friendly statutes of limitation regarding sexual abuse crimes against adults, teenagers, and the most vulnerable, innocent, and vulnerable children. First, this proposed legislation, when enacted, will protect all victims of sexual abuse by exposing and deterring those predators who commit and the enablers who conceal this horrific conduct. Secondly, it will provide an avenue to help all the wounded victims by giving each of them a chance for healing, closure, validation, and justice. Victims of sexual abuse need this legislation to be passed, so their cries for help will no longer be silenced by the statute of limitations. Repressed memory is real. Post-traumatic stress disorder is real. Victims of sexual abuse deserve and are entitled to seek justice. Thank you.
Thank you. It looks like we do have a question from Representative Filler.
Thank you, Chair. This is for Representative Brixey about the substitute, and I believe this is offered for House Bill 4486. The bill as written in front of this committee, all government actors lose their immunity, and I guess my understanding would be the purpose of that would be to cast as wide a net as possible for victims. The sub, meanwhile, if I'm reading it correctly, limits the governmental immunity to public schools, colleges, and universities, and removes cities, townships, counties, DHHS, Department of Corrections. So I guess my question would be, why are we treating victims differently who claim assault at a municipal level than those who claim assault at schools and university? That seems very cynical.
So would you like to have an amendment and support that, adding those all back in? Would you be supportive of the bill if I provided the sub replacing the legislation in its original format?
I guess I look forward to learning about the reasons for the amendment, but I do.
Okay, so I'll explain it to you. As I said at the beginning, we had dozens of meetings with stakeholders, and one of the things that my perspective and lens of does this bill work, do these bills work, is if there was another heinous sports doctor or other bad actor at a university or a school that it turned out had serially sexually abused hundreds, if not over 1,000 innocent people, Would Michigan law allow them to come forward and seek justice? And if the bills, as they're before you today, are enacted, both Larry Nassar survivors and Robert Anderson survivors would have a pathway to justice. Our children are one of our most precious resources, if not the most precious resource, and we have a duty to protect them. Children spend the bulk of their lives outside of their homes in school, and so it makes complete sense to not allow educational institutions to hide behind a cloak of immunity if they knew that they had a serial sexual pedophile in their ranks.
Representative Devendorf?
Thank you, Representative, for all of the incredible work you've done on this. I know it has been a bear, and thank you, sir, for coming and sharing your story. I think that we would all really prefer for the bills to be as strong as possible, and yet it has taken so much work to get here, and this would still be progress. So I really appreciate that. I do acknowledge, in response to Filler's comment, that we are on our way in Michigan to trying to establish a more even playing field for everybody to ensure that there is no special consideration regardless of where you are. If we can someday get to a place in this conversation where government immunity can be removed, I think that some folks would be open to it. Just as you know, Representative, that I'm very open to extending the latest age of disclosure, because we ideally would not be making public policy related to sexual violence based on an average age of disclosure, especially as with sexual violence, people disclose later and later as the stigma is lessened, or as we are more willing to have a public conversation about sexual violence, which is why we are starting to thankfully hear about more survivors of sexual violence who are men. Who are LGBT, because that stigma, the conversation is becoming a more open public conversation, which also means we are going to hear from people as they get older about their trauma and what caused PTSD and impacted their lives so much. So this is a beginning, Representative Filler, and folks who are opposed to it still at this point, and this is a result of a lot of compromise, but further down the road, several of us would be happy to make it even stronger, and several of us who also do a lot to advocate for due process and the rights of folks who are accused as well, still see the value in opening up this window and allowing justice. So thank you so much, Brixie, Representative. But absolutely, that conversation will stay open for you. Thank you.
Any other questions for the bill sponsor? Okay. We did receive numerous cards, which will become part of the record, and I have a couple of folks who would like to testify as well. Sean Sutherland and Cheryl Collins, if you don't mind coming up to the table together. We are under a little bit of a time constraint. I apologize in advance, but I'm going to have to limit your testimony to about 3 minutes. Go ahead and get started whenever you're ready.
Do you want to go first?
Sure. Okay. Some of you received an email, so good morning. So some of this may be repetitive, but I think the ears and eyes in this room, it would be necessary. So if you cut me off, I guess that's what's going to have to happen. So my name is Sean Sutherland, and I recently became aware that many of you, I wrote this yesterday, are on the eve of a momentous and powerful opportunity to influence real change in our state and in the lives of the victims like myself. It is with this information that I would like to take a moment to share a voice as to why this is an important step in the right direction. On September 18th of this year, I attended the sentencing of Gerald Sutter in a downtown Lansing courtroom to a meager audience of law enforcement and media. I awaited the moment that only a few had made to share their story in the form of a victim's impact statement. Here it is. My name is Sean Sutherland, and I was a victim of Gerald Sutter. Nearly 25 years ago, I was identified, groomed, manipulated, isolated. By the way, I'm 41 now, to clarify some math. And then sexually exploited for his horrible ends. He saw a young boy without any parental oversight and sound guidance as a prime target for his personal satisfaction. This happened over the course of 2 years. I was taken advantage of sexually on numerous occasions. During this time, I was gaslighted in the truest sense of the term, made to feel inferior, able to be discarded, and ultimately I was convinced, out of fear and embarrassment, that I was responsible for what was happening. Jerry used my unfortunate emotional and financial situation and parental abandonment to coerce and manipulate me into a secret relationship of control and abuse. These crimes have stolen my self-worth and left me feeling broken. Living with the knowledge of what took place left a heavy burden of shame, guilt, and countless sleepless nights replaying those events in my mind, questioning what I could have done differently to avoid being a victim. The constant reminder imprinted in my brain and mindset has tainted my perspective, dominated my own view of personal value, and uniquely distorted future relationships with my inability to trust others, scarring me indefinitely. This terrible abuse led to my own self-abuse and triggered poor coping mechanisms with the use of drugs and alcohol, which I battled for many years after. By far the deepest impact, and I would appreciate you paying attention for the rest of this, with the most respect I can give you. Which I battled for many years after. By far the deepest impact has been the relentless, self-induced guilt that I had somehow, in some way, done something to deserve this, and I did not. I refused for many years to believe that I was a victim. Rather, I refused for many years to believe I was a victim, rather that I was culpable. This is the profound and convoluted toll that predatory trauma of this nature can exact upon its victims. This was directed to Jerry. You are a predator, and regrettably, due to our fractured legal system, you have not yet faced the full consequences you rightly deserve. I use the term yet because I am committed to pursuing every possible avenue and leveraging all available resources to reform and amend the existing laws. My goal is to ensure that victims like myself can ultimately overcome the enduring absence of justice experienced within this haven our lawmakers have granted monsters like you. Fear of judgment and persecution kept my mouth shut for far too long and too many years. However, when I found individuals that I could truly trust and confide in, I then began to heal. While the deep wounds have scars that have forever shaped my life, I am putting my foot down and closing the door on that today. I have learned that no one person or event can dictate my value. My value began and remains in the hands of my Creator and how He sees me, and this is the truth. I want to thank the court and all of those in attendance for listening and for the support that has been provided to the victims of this despicable human being, if we can call him that. My only ask is that each of you takes the opportunity to reflect, to become open-minded and curious enough as to how you can assist in the restoration of justice that continues to be missing for victims like myself and others here in this room, as well as those who are still unable to share their story. My motive in sharing this information is not to elicit pity or kind words of my courage, but to illuminate the void of justice that our state government has allowed for too long towards victims of these types of crimes. Because of the statute of limitations, there has been an absolute truancy of justice to protect and uphold the rights of those who have fallen prey to the past evil acts of another. My silence and fear has now created a wall that blocks me from closure and reparation. The ridiculousness that victims like myself must now plead with lawmakers to seek improvements in obsolete regulations that prevent recourse is an absolute insult. In a world that continues to promote an evolution of empowerment for the weak and touts a pride in providing strength to those neglected by wrongdoers, it seems unbelievable that these archaic laws still exist. Unfortunately, I have come face to face with the reality that my horrible experience will not ever result in any personal justice in either a criminal or civil case due to the perverse statutes that have created incredible safety and shelter to these criminals who now have time truly on their side. This is the reality as well for so many others, not only within the Sutter case, and I would highly encourage all of you to take a look at that, but countless persons statewide that have been destroyed by predators just like him. My question is similar to the one within my statement. Do you want to perpetuate the indifference, or will you take a stand to the mismanagement of our state and the disregard for those who have been objects of evil in the most depraved of ways that humans can harm one another? If you need a voice, I can be that. However, what I think is needed is a true reflection of the humanity of the situation. We are not being seen as victims worthy of justice. That is the reality, and that, I believe, should be impossible to avoid. Thank you for taking the time to hear me. I appreciate it. Sorry if I went a little long.
Sure. If you could be a little more succinct, I'll give you some leeway though, because Mr. Sutherland here did go to about the 7-minute mark. So
I'll be succinct. So, my name is Cheryl Collins. I am a mother of a 19-year-old son who's a baseball fan and a player in this community. Almost 1 year ago today, on October 28th last year, I was watching the news and I saw that a umpire had been arrested for sexual conduct against a minor. That man was Jerry Sutter. That man was a mentor to my son at that time, to the point that I had invited him to my son's graduation open house in June of 2022. He was a serial sexual predator, and he groomed my son. At this moment, my son said that he has not been a victim, that he was only groomed. I'm not going to go into the details of what I'm going through and my son's going through right now, but I know that when I was in the courtroom on the day that was just described, several victims that came forth only got to be heard because there was a plea deal made with the defense attorney that victims that had exceeded the statute of limitations would be allowed to have their voice heard in the first criminal trial of a predator who was respected and trusted by almost every member of this community whose son or daughter had played sports. And they weren't going to be able to be heard because of the statute of limitations that we are pleading with you to overturn. I appreciate your time. I appreciate your thoughtfulness, and I appreciate you listening. And I ask that we rise above partisan concerns and stick up for our children, because it could be you sitting here.
thank you. Thank you both. We're going to briefly go at ease at the call of the chair. Justice Committee will return to order. Representative Filler has some amendments. Understand he has one for HB 4482. Would you like to speak to that briefly?
Yes, I would. Thank you. The amendment for House Bill 4482 eliminates the reviver period and takes it back to current statute. The way I read the bill in regards to the revival period is that in the next 2 years after this bill becomes law, any civil claim for an alleged assault can be brought as the statute of limitations no longer applies. And I would argue that the revival period allows unprovable claims from many years back to be pulled into the courts, and I view that as a distortion of the justice system, really bad for the rule of law, bad for evidence, bad for individuals. And so I offer my amendment on House Bill 4482.
Madam Clerk, please call the vote.
Chair Hope. No. Representatives Andrews.
No.
Carter.
No.
Breen. Young.
No.
Arbit.
No.
Devendorf.
No.
Cerniglu.
No.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris. Bagul.
Yes.
Madam Chair, you have 5 yeas, 7 nays, 0 pass. The amendment is not adopted.
Thank you. Representative Carter moves to report HB 4482 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
Pass.
Bazat.
No.
Harris.
No.
Bagul.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. House Bill 4482 is reported with recommendation.
Thank you. Representative Young moves to report House Bill 4483 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
Pass.
Bazat.
No.
Harris.
No.
Bagul.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. House Bill 4483 is reported with recommendation.
Thank you. Representative Arbit moves to adopt the H1 substitute for House Bill 4484. Madam Clerk, would you please take
Chair.
the vote?
Oh.
I'll accept that motion after we vote on the substitute. Thank you.
Can I have a second? Okay. So,
Arbit.
adopt the H1 sub to House Bill 4484, motion by Representative Arbit. Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 7 yeas, 0 nays, and 5 pass. The substitute to House Bill 4484 is adopted.
Thank you. Now Representative Filler's motion to amend HB 4484, if you'd like to speak to that briefly.
Yes, it just eliminates retroactivity for old claims.
Representative Devendorf moves to report House Bill 4484. Oh, I'm sorry. Oh, I skipped the vote. I'm so sorry. Madam Clerk, please call the vote.
To adopt the filler amendment to House Bill 4484, substitute H1, Chair Hope.
No.
Representatives Andrews.
No.
Carter.
No.
Breen. Young.
No.
Arbit.
No.
Devendorf.
No.
Cerniglu.
No.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagul.
Yes.
Madam Chair, you have 5 yeas, 7 nays, 0 pass. The amendment is not adopted.
I'll now take a motion from Representative Devendorf to report House Bill 4484 with recommendation as substitute. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat,
No.
Harris.
No.
Bagul.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. House Bill 4484 is reported with recommendation as substitute H1.
Thank you. I'll accept a motion from Representative Filler to adopt the amendment for House Bill 4485.
We voting on 445 today? Oh, okay.
Yeah.
All right. Yeah, this is my amendment for House Bill 4485. This deals with criminal convictions. The way I read House Bill 4485 indicates that under this bill, there will be no statute of limitations for second and third degree CSC criminal claims anymore. And in my review and the review of some attorneys, this bill violates the Constitution's ex post facto clause, essentially making a claim liable for criminal conviction when that claim was in the past not liable. And so I do think this bill is unconstitutional and unfair and moves the goalposts in the criminal courts. And my amendment would prohibit retroactivity on the criminal statute of limitations, and I move my amendments.
We're going to go at ease at the call of the chair. We will return to order. Representative Filler moves to adopt
I move my.
his amendment. Okay.
To adopt the filler amendment to House Bill 4485, Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Begol.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. The amendment is adopted.
I'll now take a motion from Representative Cerniglu to report HB 4485 as a new sub. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris,
No.
Begol.
No.
Madam Chair, you have 7 yeas, 5 nays, 0 pass. House Bill 4485 is reported with recommendation as amended as a new substitute.
Thank you. Representative Andrews moves to adopt the H3 sub for House Bill 4486. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat,
Pass.
Harris,
Pass.
Begol.
Pass.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. Substitute H3 to House Bill 4486 is adopted.
I'll take a motion from Representative Filler to adopt the amendment for HB 4486.
Yes, I would like to speak to my amendment quickly. This eliminates the retroactivity written into House Bill 4486, and we think that going backwards is a distortion of the justice system, and I offer my amendment. Thank you.
To adopt the filler amendment, Chair Hope,
No.
Representatives Andrews,
No.
Carter,
No.
Breen, Young,
No.
Arbit,
No.
Devendorf,
No.
Cerniglu,
No.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Begol.
Yes.
Madam Chair, you have 5 yeas, 7 nays, 0 pass. The filler amendments are not adopted.
Thank you. I'll take a motion from Representative Carter to report House Bill 4486 with recommendation as substitute H3. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
Pass.
Bazat,
No.
Harris,
No.
Begol.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. House Bill 4486 is reported with recommendation as substitute H3.
Thank you. Representative Young moves to adopt the H1 substitute for House Bill 4487. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat,
Pass.
Harris,
Pass.
Begol.
Pass.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. The substitute is adopted.
Representative Filler moves his amendment for House Bill 4487.
Thank you again. Offer an amendment to eliminate the retroactive nature of this. Thank you, Chair. I move my amendment.
Madam Clerk, please call the vote.
Chair Hope,
Yes. Oh, excuse me, no. No, I'm sorry.
Thanks, Chair.
I'm really, I'm sorry.
So Chair Hope,
No.
Representatives Andrews,
No.
Carter,
No.
Breen, Young,
No.
Arbit,
No.
Devendorf,
No.
Cerniglu,
No.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Pagol.
Yes.
Madam Chair, you have 5 yeas, 7 nays, and 0 pass. The amendment is not adopted.
Thank you. With this many motions and substitutes and amendments, I was bound to mess something up. I apologize. I'll take a motion from Representative Arbit to move House Bill 4487 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller. Bazat.
No.
Harris.
No.
Pagol.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. House Bill 4487 is reported with recommendation as substitute H1.
Thank you. Representative Devendorf moves to excuse absent members. There being no objection, the motion prevails by unanimous consent. And there being no further business before the committee will stand adjourned.